see a lot of faces from yesterday and a lot of more new faces today. I'm Nidhi. I've been working with ESG for a short while now, and I'm really glad that you're all here to celebrate this milestone with us. So, without further ado, I'd like to request Leo Saldanha to introduce our esteemed guest for today, the Honorable Mr. Justice Sunil Dutt Yadav.
I consider this my privilege to be able to reintroduce a dear old friend and fellow activist who is now judge of the High Court of Karnataka. I say that because I recall when Justice Yadav was, as a student, we had just started ESG and he came to us and he had lots of questions about our work. And that's when we came to know about his zeal for the public interest. And then when he became a full-fledged lawyer and took over the practice of his father, late Mr. Siddhappa, there was many an opportunity for us to interact with both Mr. Siddhappa and Justice Sunil. When he started his practice, one of the remarkable cases that I recall that he worked on as we started interacting with him was the right to bury someone. And I remember the plight of those people who had dead bodies which they could not bury because they were Dalit. And I think this was in the district of Kolar, if I'm not mistaken. And he took on the cause, and against what was a very conservative system, he managed to get them from the High Court relief so that the dead can be buried. So that's the plight of Dalits in this country. That not only when they live they suffer, and even when they die they suffer. So that really struck me as a remarkable feature of his efforts in appreciating the value of the Constitution and the promise of the Constitution. So we took case after case to him, and one thing I remember is when I took the case and sat in his chambers to work, we also had the benefit of the wisdom and the depth of knowledge of his father. And in styles, I can say they are absolute contrasts. His father was an extrovert and Sunil not. So father would be articulate and even vociferous, and Sunil would be just listening. So we wouldn't know what's happening in his head. At least in his father's head we knew because it was freely flowing. But I should tell a story about his father. And it was a land acquisition matter, and it had gone on too long. And the farmer was not only in penury, but I think he was digging his own grave now. There's no hope for him on this planet. His father took up the case and managed to get him relief finally from the lower court. And the court was deeply troubled by what was going on and said, what kind of relief do you want? And his father said, I want the chief secretary's chair. So nowhere in any pleading had such a demand been made in a petition, and he was asking for the chair of the chief secretary. I remember it was Dr. A. Ravindra at that time, was the chief secretary. So he got the thing at 10:30, 11, he got the relief. So the court directed that the chair of the chief secretary will be handed over to Mr. Siddhappa. Then he tells Sunil that, go get the media. And he instantly calls me and said, I need media. I said, it's 10 o'clock, the media sleeps late and they don't wake up this early. He said, no, but this is happening and we have to make this known to the people. So he managed to get, this was days when TV cameras had big, they have big cameras, not digital cameras. So imagine the spectacle of his father finally walking into Vidhan Soda, and when he is walking in, a horde of cameramen following him, and he brushes aside the police, despite the security, walks up and tells the chief secretary, get out of his own office. And he had that kind of, sort of character. And the chair was taken and deposited in the court. Of course, the relief was also got. But this kind of jurisprudence, okay, so unless you imagine what it means to hurt people badly and how to restore that hurt, you can't ask for this demand. And this was done, and it's recorded somewhere on the TV channels. And when we started working with the contrasting characteristic that Justice Yadav has, his response was studied, and the only adjective you would use is okay. How are you? Okay. Is this good? Okay. Is this bad? Okay. So, I mean, we used to ask him, but we need to know if it is really bad. He said, no, it's okay. So, even now, just the other day I was talking to him and he said, is this okay? And he says, okay. So you can't really read his mind. So I think right then he was made very well to be a judge. Because one of the characteristics of being a good judge is you should never really reveal what you're thinking. And I think he did it exceedingly well as a lawyer and does it, I think, even better as a judge. We have worked on many cases together. One of the first cases we fought together is, in fact, the way we worked is he would represent Environment Support Group and I would be party in person. So I had not found a lawyer in 1997, so somebody told me, you can argue your cases yourself if you're not a lawyer. So I started, and my first case was against the Kudremukh mine. When nobody imagined that you can challenge a huge mining enterprise in court, I just did it, and it worked. So I said, why not, and kept on going. And for me, the trouble was, how do you talk through the nuances of the conservative judiciary we had then? And that's when I met Sunil. And he said, why don't we do it this way? I will argue for ESG, you argue for, as a party in person, you bring in the technical stuff, I'll bring in the legal stuff. And we worked like that for what, 14 years, I think, almost, and multiple cases. One of the first cases was in 2005, when everyone was talking about public consultation, consent, hearings, and so on, especially in urban matters. And he managed to convince the division bench how critical that is, that you understand what people's imaginations are, and that you can't do that if you gag them with bureaucracies. And he got an order that all public infrastructure projects must be preceded by public hearings, because the statutes were silent on that. We used that a lot, and we stopped multiple terrible projects. For instance, at that time, we had a huge effort to widen roads. Now, when you think of urban constructs, one of the things that people, and the problem I have with our senior bureaucrats going abroad or politicians going abroad, is they come back with the worst ideas. At that time, I think Mr. B.S. Patil was the chief secretary or infrastructure secretary. He came back from Shanghai. And I still recall when he walked out of the airport, the journalist asked him, what do you think should happen to Bangalore? He said, we need roads like Shanghai. And that's when I thought, here starts our misery. 91 roads were listed for widening. And one of the roads listed was a 500-year-old road called Avenue Road. It has an history of 500 years. And over 500 years, the width of the road has been slightly encroached by the shopkeepers who were earlier residents. But by and large, it has gone through many transformations, and the characteristics still remain. As someone put it, it's the largest poor man's supermarket in India. Because if you just go there and then sort of radiate out, you're fascinated by the extraordinary amount of stuff that is being traded there. You can put together anything from a farmer's implements to almost a supercomputer which can launch a satellite, because all of that is sold there. People don't know this because people don't go there. It's not a mall. And the days of mall had not yet hit Bangalore, but here we were destroying a mall which had been constructed out of people's amazing sense of need, diversity, and celebration of trade in its best sense. If you go there, you see Akkipet, Chickpet, each of this is designated for a particular trade and continues even now. And this road was to be widened to 80 feet and then even more. At which point, we were thinking, how do you stop this? Which is when we had Dr. Subrayan Prasanna from the Indian Institute of Management, who unfortunately can't come because he's not keeping well. He started talking to us about the importance of bringing due process through the town and country planning legislations. And we started understanding it, but Justice Yadav made us read between the lines and showed us how certain provisions of law, which none of the judges had ever read into their judgments, should now be explored. And we started using the Town and Country Planning Act of 1961, which, despite conservative, was at our disposal to be used for progressive reforms. And we managed to stall the expansion of 91 roads and eventually 416 roads. But in doing that, we actually had to go to the court. We went in a PIL, and the matter ended up before Justice Gopal Gowda's bench. And Justice Gopal Gowda, who then later on became the Supreme Court judge, he asked us, these are matters of great complexity. You are thinking of re-engineering a city in such rapidity, I don't even know what we are doing. So what do you suggest? So I recall Justice Yadav said, why don't you have an interdisciplinary committee? And he said, what does that mean? He said, well, you give me a set of names, we'll give you a set of names, you put them together, and let them attend to the nuances of what the government proposes, the city proposes, and produce a report so it becomes easier for you to pass a judicial order. And thus began another amazing process where we actually had a committee set up where we recommended 3 people and the state recommended 3 people, and together that committee started hearing auto rickshaw drivers, traders, people with mobility challenges, bus users, just about everybody who is otherwise silenced. But in exploring the various dimensions of what a city is, we started documenting it. And there's an excellent film called Our Metropolis made by Gautam Sonti and Usha Rao. Usha should have come, but her mother is not well. And they basically followed us everywhere. They followed everything that was happening in the city over 5 years and put this documentary. So if you watch that film, you'll actually see the transformation of Bangalore in these 5 years, but it is actually not just about 5 years, but the transformation is about how long-held traditions were fundamentally destroyed and certain new infrastructure was imposed on the city. The documentation also spoke across the country because this was not just happening in Bangalore, it was happening across the country. In Delhi, for instance, the BRT was shelled and the metro was put there. In Bombay, the Reliance was putting its metro, Hyderabad. So people started calling us, and we actually became like we didn't have online Zoom and all that. Almost every day there were workshops on the phone where people would call and ask us, how do you decide this, how do you do that? And across the country, the importance of ground-up action through the procedures of law, not just protest, is actually the craft that Justice Yadav taught us. And we have used it and we continue to use it, and we say protest, yes. Slogans, yes. They're effective, catches attention. What is the next step? You need to have the next step. And he always said, for the ends of justice to be met, you need to know every step. You cannot get from here to the door unless you have the intermediary steps. And those steps are always silent. They're not noticed, but they are critical steps. So he explained to us, he trained us, we worked with him, we learned a lot. And we challenged the road widening project. In the challenge to the metro, you saw the metro which is running here. This metro, when it runs past the Southern Circle, it would have destroyed 3 kilometers of the boulevard which you see. We had road campaigns. Yesterday Vinay came. Vinay was one of those guys who really mobilized large numbers of people. And we campaigned here for 30, 40 days. Lalbagh, entire stretch of Lalbagh would have gone. We got Justice Kumar and Justice Nagratna, she's now in the Supreme Court, to come to the site and appreciate what it means to destroy the western end of Lalbagh, the implications. Not just the historic and cultural value, but also the biodiversity impacts. So this was the way in which the city was questioning many of this infrastructure. But we realized it is not just Bangalore questioning, it is all of India has the same problem. It is a construct of developmentalism which needs to be critiqued and questioned and contested. And we protested while he helped us craft the petitions. And the PIL that resulted in a remarkable order in 2011 came from Justice Kehar, who was then the Chief Justice of Karnataka, but eventually Chief Justice of India, in which he said, he warned, and this direction was given to, yesterday Kumar Naik, who was the Commissioner of BDA, was here. He directed the officials to ensure that every value, nuance, and proviso of the Town and Country Planning Act is complied with in its letter and spirit, failing which, he said, individual officers who are meant to implement that will be held accountable under contempt of court. Now, not many people use this brief order, but this order itself is remarkable in telling us how extensive the impact can be by using this powerful forum. So this order also came because Justice Yadav was there arguing that case. But one other case that he fought with us was on the privatization of lakes. how do you actually imagine water bodies which have been there? You don't know who owns, because, like we use the term tragedy of the commons. And Gareth Hardin wrote this terrible paper in 1968 with the same title. Our problem with that paper was we don't see what Gareth Hardin was seeing in 1960s in India, because the commons are alive and well, and people are using it and reforming it, but not destroying it. And here the state was coming with an idea that the commons with the people is terrible, the state is a better custodian. So how do you respond to that challenge? Because lakes in Bangalore were being privatized. Hebal Lake, which some of you came from the airport would have seen, had been given to Oberoi, and like that, several other large corporations had grabbed lakes. And they wanted to put up hotels, theme parks, all sorts of funny things which should not belong to that water commons. And while we responded to that, the depth of jurisprudential research that came from him and his colleagues in his chambers, if you read the petition today, the PIL that we drafted and fought, and succeeded in winning on April 11, 2012, with another remarkable order, which is the governance of the commons should be with the people. And for which the state was saying, but no, we are there, we have created parastatal agencies. So the court agreed with us and said parastatal agencies are undemocratic constructs. They have no business being owners of the commons, because the commons belong to the people. So people must govern it, like it has been the tradition of this region, and from the Harappan times. So the construct was every lake can have its own lake protection committee. And if they cannot manage to protect the lake, then there will be a district lake protection committee, which is a kind of an intersectoral body of various agencies. And even they were sort of not trusted to deliver, because the encroachment and pollution and diversion of lakes was so widespread and rampant. It was creating food insecurity, water insecurity, health insecurities, many insecurities. Everybody is crying, but nobody is providing a solution. So he came up with that idea. Let's propose this to the court and see what happens. And it was taken up. And today, Karnataka High Court's order in April 2012, which is based in turn on a set of guidelines, Justice N.K. Patil was then a sitting judge of the High Court of Karnataka. Last year we had a conference, and Justice Patil, who is now retired, had come. And he said for the first time in the history of free India that a sitting judge was asked by the Chief Justice then, again it was Justice Kehar, to initiate a process of going out and finding out. It was, usually you appoint retired judges, but here was a sitting judge going out and finding ways to solve a very complex problem. So if you read the Justice N.K. Patil committee findings, which in fact when he did it, it took into account Justice Yadav's depositions, my depositions, and everyone else. The public at large was invited to come to the High Court and depose. And we sent, many people came. But most importantly, he made 9 agencies of the government to sit with him in every meeting. And it went on very long. And eventually, that report is not only binding on protection and rehabilitation of lakes of Bangalore, but of all lakes across Karnataka. At that time, we came to know we had like 33,000 lakes left. But because of that order, each and every lake is on the maps are being measured, and the number has come to 43,000. Just last week, there was a report from the Ministry of Water Resources. I don't know who asked them to do that, but they have put out a report saying Karnataka's lakes are 26,000. And why Delhi has a business in a state list, I have no idea. But that's an attack on federalism, and we must fight it. And also cutting off half the number. So that's a serious problem. But that said, the final PIL that we actually worked with him on before he became judge was what we shared with you yesterday as well, is the exploring when biopiracy in the BT brinjal promotion was suspected, and our research confirmed that there was potentially illegal access of brinjal varieties by Monsanto. We went to him, and he came. The way we worked on PILs then was just, he would just come over after his chamber, 6, 7, 8, and then we'd sit till 2 in the morning, and next day morning again, 9 o'clock is in the chamber, and going to court. So we had to do that because, we had to, he did it all pro bono. We couldn't stop him from doing his private practice, but at the same time, we wanted the benefit of his support, and he was available to us all the time. And in crafting this petition, the investment that was made in terms of finding from across the world ideas of ownership, sovereign ownership of bioresources, that is of the people, not of the state. That was what was explored. That VIL, which was in cold storage for 10 years, has just been restored and will soon be heard by the Hon'ble High Court of Karnataka. And I share all this to suggest the value of this man. And I'm so grateful and happy that he is now on the bench and with enormous powers to do right from a forum which can deliver it. And we hope that all of you can explore the possibility of reaching out to this forum. I know it is a very complex system. You still have some very colonial ways of addressing people on the bench. But that apart, if you overlook those ways, there's a lot of opportunity to set things right in this country. And I really look to Justice Sunil Dutt Yadav's jurisprudence and leadership from the bench now in setting a path in motion which would actually result in, I don't know, maybe 20 years later we come back and we speak of his judgments like the way we spoke today of his lawyering skills. Yeah, thank you so much, and I welcome you. Yeah.
A very good morning. Leo Saldanha, Team ESG, and all dignitaries. Before I go on to share some of my experiences, I would like to start as judges usually do in a very formal manner. I've prepared a small write-up last night and hope it conveys what I really intend to convey. Environmental justice is justice to Mother Earth and justice to the living race. Efforts to fit it into an objectively verifiable framework has resulted in judging the achievement of environmental justice by accepted norms and standards. However, a far more interesting perspective on environmental justice is its subjective perception. Just as justice defies a definition and has been referred to as an idea of justice, often it has been a subjective vindication of rights. Perception of others as regards such vindication by individuals in movements is that the individuals are consumed by their subjective attachment and is an extreme reaction far from an objective approach. Attempts are frequently made to discredit efforts and movements on such score, attacking them as being driven by exaggerated and reactionary concerns, and very often malefides being attributed. The need of the time is for a balanced approach, which again is based on a perception of outsiders and confined to a judgment by those who do not necessarily feel for such cause, but that's how it would remain. Time has come to respond to the perception of others by evolving and adopting long-term strategies based on objectively verifiable and sustainable methodologies. There is a need to engage with the system and its remedies and tools in achieving goals rather than be scornful of mainstream systemic grievance redressal mechanisms. Not engaging with the system would result in confining movements with legitimate goals to what others construe to be at fringes and risking branding of movements to be elitist, removed from reality, and as those instigating extreme responses not acceptable to society. The history of successful struggles are movements based on long-term aspirations, built on a strong rationalist foundation which actively engages with the system. Accordingly, litigation interventions form a part of such engagement which requires to be strategized with realistic goals and aspirations. Litigation as a grievance redressal mechanism is to be invoked at an appropriate stage after strategic decision making. The choice of the legal fora is of prime importance and must be preceded by a trail of engagement with state authorities, which the courts perceive to be a necessary precondition. The choice of the fora would also depend on the relief sought for. Once the litigation has commenced, its conduct requires to be strategized and case built up by resorting and invoking legal tools as available in the substantive and procedural laws. The choice of the legal fora could be that of the trial courts or the courts of record, which are the constitutional courts. The resort to class action before trial courts as available in procedural laws ought to be explored, especially where the case would require collection of evidence through court, which would enhance the credibility of the evidence itself. This may also be the choice where reparation and compensation is pleaded. The courts of record could be invoked for short-term interventions and long-term directives and directions, but appropriately. Now I would like to share some of my experiences as a lawyer, and then having transformed myself into my present position, and the impression that I get after I look back at some of the campaigns that ESG conducted, where the campaigns were one on the public front and accompanied with legal interventions, is that legal battles are fought after much strategization. And the courts of law need not be the first option available, but would be required to be invoked at appropriate stages. And how it is invoked and used to get relief is a matter of strategy, objective thinking, to be divorced from emotional responses. And that's how the system works. And I always was of the view, even as a lawyer, that we need to play it by the rules of the game as are prevalent. And that's the only way to engage with the system. And many of the legal interventions that we initiated through ESG were those which never culminated, because that's what PILs are required to be a continuous engagement by society, with society, through the medium of law. And the continuing mandamuses and directions, such as in the Lakes case, were eye-openers to what courts could do. It's a fact that interim relief was hard to get in many of our litigations. And the Lakes case went on for quite a long time before we did get some interim direction. And the direction that we got was simply that lakes ought not to be privatized. And it's something which others may consider is nothing at all, for that's something that's accepted. But that's not how it is. We are in a system where the crisis in the legal system, as the jurist Upendra Bakshi has stated, is in getting an order for adherence to law. The culture of adherence to law is such that we need a reiteration from the highest courts for adherence to law. And that's how the system is, which we need to understand and deal with such realities. That said, engagement with the system is indeed an essential part, and it is possible that at some time during the course of the litigation that you have some minds which are open to these views. judges also, being human beings, have their prejudices, both negative and positive, and in light of how the system is designed, there are constraints. But every legal intervention, especially relating to environmental justice, are long-term judicial interventions, and at some point you will find that the institution resonates with your idea, and the system reacts slowly, and that's how the system functions. And that patience we require as we are dealing not with an individual case, but the life of Earth. And as I have stated, it is justice, and justice not to an individual, not to a movement, not to a group of people who are litigating, but justice for Mother Earth. And such long-term causes require long-term responses, and you need patience. And that's it. So I appreciate the legal interventions of ESG, but I find that interventions are lesser in the legal field as of now. And it's my view, no, it's my view that we need to engage with the system. The fight for justice cannot be merely an idea of justice and a subjective romantic idea, as I say, but must be translated into concrete and objective struggles for justice. And the struggle should go on. And the faith that the common man has in the system sustains that struggle. And all struggles are long-term struggles. It is not necessarily that we achieve what we want to, because that's always a distant dream. But it's the idea of justice, of having fought and lived to see another day, and to have pursued a passion with the resultant product that we have made Earth a better day, we have made the legal system a better day than what it was yesterday. And if we keep this in mind and continue our fights for justice within the system as per the rules of the game, I think we have done our service to society. Thank you.
Yeah, thank you for this brief but powerful message. In a time when I think there's a lot of confusion about the idea of justice. And there's also a lot of sort of dispirited engagement with the forums of justice. So I think your message speaks clearly through that sense of despair, and I really hope that we can grapple with that message and do what we should, not what we can, but what we should, so that we can have a better day tomorrow. So I open the floor for questions. I'm sure that there are thoughts in your mind to reflect on.
Thank you, Justice. That was a very clear elucidation of what needs to be done. I think your focus is on, let's do the right thing, not things right. My question would be on this, the point you made about we need to play by the rules of the game. I'm wondering if the rules of the game are tweaked to foster the interests of those who want to destroy the environment. So how do we fight that?
That's again a rule of the game. And that's how the system is. There are divergent thoughts, there are divergent ideas, and we as judges have our own views of things and matters. Often it is the right moment which we should wait for, and gauging and utilizing such strategic times, we need to conduct our struggles. And it is a fact that there are strong views, and judges are not free from them when they sit on the bench. But judicially trained minds, irrespective of their prejudices, often deal with matters objectively, and that's how the judge should do. And with that faith in mind, we need to carry on these struggles. And often, if you find that there are certain responses, you can take it that those responses will change, and everything is a cycle. So we need to have the patience and weather it out and continue our struggles. For the consequences are not so much of our concern, and it's only our efforts.
I am Narasimha Reddy from Hyderabad. Just as an extension of this discussion on rules of game, I think what we are seeing now in the last 10, 15 years is, bureaucrats who are to work within the framework of constitution and the law. Now they are increasingly sitting and, preparing plans on how they can deviate from those frameworks of law. And on the other side, people like us who have been, asking earlier how to interpret widely that framework of law. And today now we are asking why can't you work within that framework of law. So you can see increasingly the law, the bureaucrats who have to work within the law working against the law. So what can we do about it?
It's a good question. And as I mentioned earlier, that Professor Upendra Bakshi has stated that the crisis in the Indian legal system is non-adherence to law. So the struggle then would shift to ensuring that the law is implemented and that the state functionaries work within the framework of the law. Of course, it's going to be an exhausting battle, but at every level of infraction of law, the state authorities are to account. And accordingly, micro-level attacks for adherence to consultation processes as per law, the use of tender mechanisms as per law, etc., needs to be resorted to. So we need to have micro-level strategies where wherever there's a deviation, we need to get it rectified without necessarily going the way of a class action, but making it a mere writ where you seek to enforce the law and ensure that there's no deviation in the performance of a certain function. So it should be a micro-level strategy of going against the authorities, having their actions rectified, and getting a direction for them performing within a certain statutory framework. And what that statutory framework is ought to be directed in the litigation and the judgment where you seek to enforce. So it is a struggle, but the struggle should be micro-level to correct it so that the path would lead to the eventual goal.
I have a follow-up on that to Narasimha's question. What if the law is itself bad, as has been the case now?
The attack against laws, of course, is a different legal battle and must be resorted to only at an appropriate stage. For courts are not ready to strike down laws at the very first attack. And unless it is really essential, it is better to fight and ensure that the law itself is adhered to. And as a last resort, if a law requires to be changed or replaced, courts are not the forum. The forum is that of the legislature. And that's where your movement should focus on getting the law replaced. The correctness of a law will be tested on legality. And the legal attack of such a law, which would play out in the court, and if it fails the legal test, would result in upholding the law, which would leave you worse off than going to courts where you feel that a law is unjust. So it is my view that the attack against the law being a last resort, your movement should be elsewhere to have the law either amended or replaced.
I understand the insistence for adherence to law, but the last decade has seen law being changed to the detriment of the interest of the environment and the people at large. Let's take example of environmental impact assessment. The dilution of the environmental impact assessment would be a question that can be discussed on the touchstone or rather on the floor of the parliament, where the judiciary has got no role to play unless a virus is challenged. And your lordships are quite conscious that whenever we challenge the virus of any rule or a legislation, there are only two grounds: violation of a fundamental right, the procedure, and whether it is a legislative competence or not. We keep this issue aside. Adherence to of law arises and expecting a law to be enforced by a judiciary, a question arises only when we have a law, but when the law is being diluted. Let us take example of coastal regulation zone notification, environmental impact assessment, Wildlife Protection Act, then this wetland protection rules and regulations. So in last 10 years, almost every legislation has seen the dilution. Let's take example of Land Acquisition Act and the Forest Right Act. They are being diluted. So how do we now compete? We are voluntary organizations. We are taking, let's say, for the state, the foreign funds, tukde, and we are perceived as an enemy of the development. So how do we engage ourselves with legislature with a different ideology, but are ruling in the majority of the states and the parliament, and try to ensure that they don't dilute the legislation? This is a field where I need your assistance.
It's a rather difficult question to answer, but I would rather have a broader response of stating that as I have indicated in my small write-up, that we need to engage with the system, and that is to stay. How we are going to engage with the system to put our viewpoint and, if possible, get the system to think like us is the challenge that we need to recognize. For if we were to pit ourselves against the system and still have a view, then it's a failure of communication of what, according to us, is something so transparent that it ought to have made sense to the others. And if we have not been able to, or movements have not been able to convince, then the only answer appears to be that we need to renew our efforts to ensure that the others, which I have stated, also need to think like us. And that is the challenge, and that is the struggle. And that's the only way we are going to deal with certain difficulties.
Environment impact assessment and social impact assessment is always done at the end of the planning process. After all the, sometimes even after the contracts are concluded, then they go for environment impact assessment. So it is those people who are insisting on EIA and public hearing and bringing up the environmental issues are seen as obstacles in the course of development. But if environment can be treated as a ground reality, as an essential, the EIA and SIA should be at the beginning of the planning process with informed consent of the people. So is there a case for us to take up that EIA and SIA should begin before the tender processes begin?
You're absolutely right. For it cannot be that we have in paper a process of consultation which remains on paper. And if it requires to be effective, and if a project needs to sail through. Time has come when environment impact assessment, social impact assessments are adhered to in letter and spirit, and micro level judicial interventions and sensitizing the state would be the only way to ensure that this moves forward. And as I had earlier remarked, the effort today is to ensure what little law addresses to be adhered, and how we ensure that will be the stepstone to achieving wider goals.
Ambedkar said that it is possible to pervert the constitution without changing its form by merely changing the form of the administration and make it inconsistent and opposed to the spirit of the constitution. And he argued that we need a culture of constitutional morality, just the constitution isn't enough. So he seems to be arguing that it is just that there be law, but the presence of law doesn't mean the presence of justice. And that there needs to be a debate about justice in other forums than the court. We can't look at the court as the sole province of justice. So what is your thought on what those forums should be, what kind of debate should occur?
No, that's essentially what I was also mentioning, that justice is justice as per law. So whether the law is just is a larger question. So the response for justice, or the craving for justice, is not only through courts, and court is only a small a part of the system, and these questions needs to be addressed elsewhere, including before the executive, before the legislature, and in building public opinion. And that's the only way we can have a change in the manner in which systems work. If it is so, as Ambedkar has remarked, that the best of the constitution will have the worst of its implementation if you have the wrong man manning it. And that's a reality which we need to recognize. And in these struggles for environmental justice, we need to be acutely conscious that we are just a small player. But it's our effort and it's our satisfaction that we have contributed to the larger system by our individual contribution. And with that solace in our mind, we need to contribute in whatever little manner so that we ensure that the world is a better place than what it was yesterday. And that's a manner of maintaining faith in the system.
I have more of a personal question. Do you find a major transformation in yourself from what you were to what you are now? Because you said that earlier.
Of course, as a judge, we are rather restrained, often glass-faced, and frankly speaking, the questions that we address to lawyers in courts are not revealing our inclination, but only to get information so that when we sit down, we have all viewpoints. And that's how an ideal judge works. And it's a rather solitary exercise that after having heard passionate arguments for sometimes you say 15 days, 20 days, finally we sit down, and when we sit down, sometimes it's a month later when we reserve our judgments. And then in the stillness of this solitary environment, we think about it, and often rationally, logically, and sometimes with whatever feelings. But it's an earnest attempt of a good judge that we come out with the right decision. No, so I see Leo in many of the lawyers who appear before me, and then absorb their viewpoints, and sometimes ask them to be dispassionate, for finally what rings in a judge's mind when he sits down to write the judgment is more of logic. But wherever there's an element of discretion, a balancing of conflicting ideas, the innate truth of an emotion never disappears, and that would remain. So it's only right that we have a sensitive mind when we approach problems, wherein there may be solutions or windows of opportunity for solutions where you may lose the battle, but a window is left open for another battle and another war.
So that begs the next question, which is yesterday's speech by Professor Sheila Jasanoff actually indicated that in a planet which is burning and in such disarray, we need a set of unruliness to guide new imaginaries to rescue the system. So do you think judiciary is so caught up with being conservative that it has lost its capacity to reimagine new possibilities?
I would rather look at it differently, for I always feel that the system itself has its foundation in a sense of consistent and persistent ideas. And any change is something that the system reacts to slowly. And how slowly or fastly is a matter that is left to the judgment of the common man. But that's how the system works. And we need to have the patience to live it out. And there may be ups and downs. But it is the faith in the system, for we live and we will live. And the struggle should always be with long-term goals. It appears very philosophical and very objective, but that's how the system is, and we need to survive and make incremental gains in whatever strategies. No doubt there may be requirement of extraordinary situation requiring extraordinary response, but then it's with you how you make out that case when judges do respond to such extraordinary situation. And it is the endeavor to place such an extraordinary situation where you want an extraordinary relief. I think I can't add better than that.
Can you give an objective definition, objective in terms of what you just said, of public interest? What is public interest?
I can't, because I agree with you that you can't define it. And that again depends on what public interest that the person who has the power to define it would look at. And accordingly, public interest varies from time and issue. And it's a matter that is to be decided depending on the matter on hand. And it obviously defies any definition. And we can't look at such definitions. According to me, there are dilemmas of deciding every matter, and every action that you take in your daily life involves a dilemma. And that dilemma is faced when you have to decide whether there is public interest. Finally, it comes down to, or is limited to, the framework of the law which contains what is public interest. So what is that legally protectable interest that is imbibed in the law is public interest for all purposes. And the only other alternative is where the law is not clear and ambiguous. You need to put out, looking into the broad objectives of the Constitution and the other laws, of what is the interest at that time that requires to gain precedence over some action that may amount to an intervention with nature.
Why is it that the judiciary has steered clear of this? They've, in many cases, left the definition of public interest to the executive. They have not intervened. And just as an argument, why can't they tie it down to say that only directive principles should define public interest?
There is no doubt that public interest is to be guided by what the Constitution says as either directive principles of state policy or other laws. But where it is nebulous, it may be left out. But courts often hesitate to trample upon what is otherwise left to the legislature, and that's a thin line. But this is a contextual question and needs to be answered as and when it arises.
Yeah, I think on that note, I profusely thank Justice Sunil Dutt Yadav for having made time. He is actually in charge of the High Court of Karnataka during the vacation this week. And yet he made time for us. I don't know if any of you know what that means. It means that he is absolutely responsible for everything that is happening in the court right now as the in-charge judge during this week's vacation. So I guess that itself is a sufficient statement of his dedication to the environmental justice cause, that he made time to be with us. But I'm sure that as time goes on and we see him in different realms, working through complex issues, we'll probably find the person's enlightenment descending into the letter of his judgments. And hopefully that's the kind of revolution we do need from the judiciary now.
As a parting viewpoint, I would just like to say that I may see many of you on the other side, because at some point I find that we meet. The world is a small place. And you may expect sometimes a very sterile response as it was today. But I'll tell you that some of us and many of the judges and all of the judges do, objectively speaking, have a public interest in mind. And I always ask a divine blessing in the sense that I hope I never will lose the sensitivity despite rush of work and the ability to decide what is right and wrong. For it is the day that you lose that sensitivity that benumbs your idea of justice. And that is the only way I look at it as on date, and hope that these qualities will remain with me so that we can engage together in whatever capacity we meet. Thank you.
Thank you so much.